self-report of the Heart Institute and the Heart Institute alone. If you look at the report, if you read the report itself, you see talk of governance, you see talk of infection control, you see talk about contractual duties, but when you look at when the interviews were, in each item of that report, it talks about interviews that were conducted in January of 2019 and the findings that were made in looking at documents over at that period of time or over the preceding 4 to 6 months. It says nothing about looking back 3 years or 2.5 years to this period of time because it simply didn't.
Did Ms. Crane lose her job because of this issue?
Ms. Crane lost her job because of the Heart Institute issue and the failure to report deaths and the failure of oversight regarding those issues. If you look at this, Judge, I apologize, Judge, but I didn't mean to cut you off, and I want your questions. I really do. The point of this is, however, that if you look at the sequence of events here, there was in fact a self-report to the Joint Commission. It was oral, and then it was supplemented with a written report. The other two reports
the self-report occurred because there was a media report out there already. Is that correct?
That is true, but there had been reports and there had been discussions beforehand.
Well,
wait
a second. Did the hospital report to whether it's the Joint Commission or any governmental agency prior to the media outing the hospital on the issue?
There was a report and a review that took place in the spring of 2018.
A report. Who's reporting what to whom?
There was a media report then regarding a heart case that was reported by the hospital to the Joint Commission. I believe, I don't have it right in front of me, I believe there was also a report to ACA and or CMS. There was a site survey that took place at that time. There was a review done, and there was a follow-up, and the deficiencies were cleared. There was, in addition to that, the entire triennial survey, which took place in August of 2018. Those documents were attached to the motion. There was none of these deficiencies found or identified at that time. So what happened here was there was concern regarding the heart program. There was an effort to address that. The regulatory authorities came in. They did a survey. They found the deficiencies addressed. There was a subsequent triennial review in August of 2018 that resulted in a reaccreditation that renewed the accreditation that was in effect at the time Ms. Kowalski was in the hospital in from September of 2015. So at the time of her hospitalization, the hospital was in fact accredited by the Joint Commission. It was in fact accredited and in good standing with CMS. There was no indication otherwise. Those facts were reaffirmed in August when there was another triennial review. When this hit the fan, so to speak, with the media report, that was self-reported. That was self-reported that day, and 2 weeks, 3 weeks, nearly a month later, CMS came in with an unannounced survey and made their report. They left. They did not find an IJ at that time. They issued the IJ on January 31st, 2019. We had 10 calendar days in which to respond. We responded. There's all this correspondence has been provided. That the issues that were raised in the IJ, according to what we sent to them at the time, correspondence from one of our senior officials, said basically, here's the plan we had already put in place by the time of the report. Changes were already underway. Here's the plan we had already implemented. Then, in addition to that, there was a proposed plan of action to address the IJ and address the deficiencies. That document was provided. Then there was another on-site visit that took place in February 20th and 23rd, I believe, of 2019. That resulted in the IJ being lifted with a plan in place that we had to abide by. We abided by it. There were subsequent follow-ups, and it was cleared. But the IJ was lifted, Judge, in February of 2019 by CMS. And obscured in all this is the fact that at or about the same time that CMS was conducting its follow-up survey regarding the IJ, the Joint Commission was also in to do a follow-up review, and that was cleared. There were no deficiencies found. And so what I'm trying to get to is this, and the point where we can show you what happened with the IJ, we can demonstrate all that, but what I don't want to get lost in all of this is this central bottom line fact. The issue that brings us together into this conversation today is the question of whether Mr. Anderson's testimony about the standing of the hospital regarding JCAHO or CMS, whether his testimony was incorrect or misleading. And the answer to that question is that it was not. And there's no basis, there's no indication in the record otherwise. All you've got to suggest otherwise is testimony that is based admittedly on supposition. Okay? When Dr. Corcoran testified, he indicated that he had never seen a Joint Commission document regarding an IJ. He had never seen any indication that there was in fact some survey in September of 2018, and that's for good reason. There wasn't one. And the point that I'm trying to get across to Your Honor is that at the time of this hospitalization, there was in fact a certificate issued that had been issued that had never been revoked and never been abrogated, that Johns Hopkins All Children's Hospital was accredited by the Joint Commission, and there was no indication from CMS otherwise.
So what is your suggestion, your game plan for today?
My suggestion, Your Honor, that if this issue is that problematic, that the jury be instructed to disregard Mr. Anderson's testimony with reference to JCAHO and CMS, and that we proceed. We would like to go ahead and proceed with the case. If at the most, if we believe that putting this entire issue before the jury, first of all, is going to result in more misleading and more confusion than anything we could possibly do otherwise. We've been trying over all this weekend to conduct discovery and conduct what amounts to a reopening of discovery with reference to matters that are fundamentally immaterial and that are fundamentally prejudicial in the sense that any prejudice far outweighs the probative value. We've been litigating and investigating a purely collateral matter. And Judge, I think we're at a point where the best and most conservative management of this situation is to proceed. And if there is some clarification, limited clarification that counsel feels the need to address in rebuttal, then let's do that. But I would implore the court to look at the circumstances and look back de novo at what Mr. Anderson actually said and what Dr. Corcoran actually said, and see that there isn't any indication that this jury was misled. There is a brief reference to this entire matter, and we're going off into a collateral matter that is going to be fundamentally confusing and highly prejudicial. And if we go down this road, we're going to have more problems than we could possibly imagine.
So when witness Mr. Anderson is asked the following question, let me talk to you about your overall view based on what you've reviewed. Did it appear to you, based on the materials you reviewed, the records, the policies, that All Children's Hospital had an appropriate safety plan in place for patient care? Answer: yes, they did. So,
Your Honor?
So I mean, that is something that the hospital adduced in front of this jury.
Yes, sir. And at the
And
time,
now you're telling me the door was not open. I mean, that's what you're telling me?
what I'm telling you, Judge, is two things. Number one, if he were to be called back, if we can get him back, if he were to be called back, the proof would be that at the time that he referenced that statement, as of the fall of 2016 and 2017, the Joint Commission on the Accreditation of Hospitals had reviewed the safety plan in effect in 2015 and issued an accreditation based on that. And there's a
Let me ask
certificate to
you
prove
this.
it. And then,
Let me cut you off. Did you even provide witness Mr. Anderson with any of this information that we've been discussing since Wednesday afternoon? Was he provided any of it?
yes, sir. We sent,
He was provided the information?
I-
Because we had an issue with what was produced to Mr. Anderson, witness Mr. Anderson. So I want you to be very clear as to what was specifically produced to witness Mr. Anderson. Very, very specifically.
since Wednesday, he was sent the certificates.
I don't care what happened since Wednesday. At the time he testified to this jury, had the defense even provided any of the information that we've been discussing since Wednesday?
May I ask Mr. Shapiro to address that, Your Honor?
Mr. Shapiro, do you want to step into the breach here?
Well, only to the extent that he was provided hospital policies and procedures, yes, sir.
That doesn't answer my question.
Yeah. I did not provide him Joint Commission surveys, no. So I don't know if he looked at anything online, but to my knowledge, no. My understanding of his just to explain, my understanding of his testimony, Your Honor, is that the fact that the hospital was able to operate at that time meant that they had gone through joint accreditation surveys. That was the simple basis of his statement that he volunteered.
Didn't even provide the information. Okay. What's next, Mr. Hunter?
I just point out to the court that we have been scrambling very hard to try to provide as much information as quickly as we can. And I believe that this issue can be addressed either with an instruction, a curative instruction, or some summary disposition. I think if we go full scale into it, we're opening a whole nother trial.
Well, plaintiffs are telling me that if I don't go into it, I'm getting another entire trial anyway. Okay. We are where we're at. Anything else, Mr. Hunter, that you would like to say before I let Mr. Whitney have a very brief rebuttal, and then we'll talk about what we're going to do.
I don't believe so, Your Honor.
Mr. Whitney, very brief, please.
I need to dispel a couple of notions. First, that these issues were limited to 2019. In what was produced to us Friday evening during the deposition, we have an ACA statement of deficiencies dated February 23rd, 2017, specifically for risk management deficiencies. The specific violations relate directly to patient rights, coordination of care, and patient family education. That was less than 1 month after Maya Kowalski was discharged. We provided that for the first time from ACA on Friday afternoon. The statement of deficiencies and the corrective action that we were provided. Mr. Hunter just represented this court that surveys don't look back, they look forward. That's absurd. They have to look back, and in the corrective action plan at page, I don't know what page, I can pull it for the court if we need to. The Patient Safety Committee reported 12 retrospective Code 15s and additional Code 15 reported during the required time frame. They're not talking about the future, they're talking about the past. Ms. Green confirmed that in her deposition. In the corrective action plan provided Friday afternoon, the risk management department was not included on the organizational chart included in the quality and safety plan. There was a failure to have them report to the medical executive committee, the president, the board, or the integration of risk management into the hospital organization structure and quality assurance program. There was found to be, retrospectively, no evidence of risk management reports or data collection in the past 15 months, and no historical data related to objective indicators of quality, all retrospective. The failure in the plan of correction, the governing body failed to ensure management of the organization. That's how that begins. The interim president accepted the resignations effective immediately from the president, vice dean, the VP chief of staff functioning as lead executive of risk management, the chief patient safety officer, and the VP of marketing and communications and culture. The director of risk management was replaced by someone in the role of vice president of medical affairs. Mr. Anderson's testimony, you know what, the court already spotted the issue, that exchange about patient care. This goes directly to patient care. The last thing I'll say, Your Honor, is that we've been at this for just under an hour, and we admit that this is a lot to put before the jury on the final day of what's supposed to be the final day of this case. For that reason, we think directed verdicts are the most appropriate way to deal with this. Rather than bringing in Dr. Corcoran, introducing 15 documents, bringing in Mr. Anderson back, they want to bring in Angela Green now, and have a mini trial on this issue, we think directed verdicts are the appropriate remedy.
You can't unring this bell.
The court has before it the question of sanctions filed by the plaintiffs against the defense. Ultimately, I'm going to be reserving on the question of sanctions. That's a bigger issue than what we have time to address today. And there's a lot of concerning issues that we'll ultimately have to work through. I need to address where we are right now, what we should do and what we should not do. I've got a situation where the defense knowingly and intentionally presented evidence to this jury that everything was fine about at the hospital at the time of Ms. Kowalski's admission. There is evidence out there that can be viewed that there is a systemic culture of problems, especially centered in the risk management department. Now, absolutely, without a doubt, it does seem that the driving force was this Heart Institute issue, but there is a view of the evidence that plainly and without interpretation could be seen as being more pervasive than just isolated to the Heart Institute. There's a view of this evidence that it is systemic, and systemic means systemic. And when we talk about culture, and I hear what the defense, they want to view, well, look, this happened in 2018/2019, so you can't look back. Culture, however, is not something that you just turn on and turn off. It's not like a light switch or buttons on this wall that I can't figure out how to turn on and turn off lights. But it goes to the essence of what an organization is. And that takes time. And a 3-year look back from a time that we know that it was spotted by regulators, both governmental regulators and otherwise, suggest, or at least there's a view of the evidence that a jury could find that this pervasive culture existed at the time of Maya Kowalski's stay at Johns Hopkins All Children's Hospital. You know, this culture might even go all the way back to the time of Johns Hopkins' purchase and acquiring of the hospital, which was, I think, 2011 or 2012. So I now have a situation where the defense presented everything is fine. And I think it's appropriate and required for the plaintiffs to rebut the evidence that the defense presented to this jury. Now, that being said, this is not a deep dive into what happened in the Heart Institute, what happened everywhere, but it goes more broadly and more high level as to what the culture was and the problems that existed, what appears to be admitted by Johns Hopkins All Children's Hospital. And I think if the jury hears that at the high level, that is an appropriate response for the plaintiffs to rebut what the defendants presented, and then we'll let the jury make the decision as to whether it's relevant or not relevant. I don't think we need to get into a situation where we have 14 days of testimony as to what happened in the lead up to, okay, you can call them self-reports, but if they happen because the media outed you, I'm not sure it's a self-report, but be that as it may, we'll call it a self-report. So I do think that there is a way we can proceed. So this is what I would suggest. Apparently there's 2 more boxes of materials. I see the plaintiff has his expert here, that you spend this morning going through the documents and let the expert come on the stand and testify at about 1:30 today. Hopefully we can finish the evidence. And then I can give jury instructions this afternoon and the parties can do closing arguments first thing tomorrow morning. So, Mr. Whitney,
I was only
thoughts?
going to say, I think there's a lot of those boxes, but we're not going to be able to have time to explore all of that. And I think we have an hour and 20 minutes left in our rebuttal. I think our preference would be to, with what we have here,
Testimony.
there's enough to put in front of him to discuss this at a high level now.
Strike his testimony, though,
And,
as counsel said.
And the other remedy, of course, striking Mr. Aaron's testimony. But in terms of timing, that's what I'm speaking to right now, is we prepared an exhibit list with 5 or 6 of these critical documents. We can get the issue in front of the jury for rebuttal this morning and hopefully wrap this thing up.
May I be heard for just one moment, since I'm the one delivering the closing? Judge, we can't unring that bell unless we strike the testimony of Mark Anderson. If the court recalls, juror number 1 asked a question which reaffirmed their point about whether the government had passed judgment or had accepted, or whatever you want to call it, approved of the actions of Johns Hopkins, that there were no problems there. You can't unring that bell unless we do something to let the jury know that that was highly questionable testimony. Because even if we come back here with some rebuttal, it's still in the jury's mind that the other guy said, well, but the government overall, they found that they were okay. And I know juror 1 at least, who's asked the most questions, has been, it was a concern to him. So we move the court to strike all or the significant portion of expert Anderson's testimony, or else we have an incredibly uphill battle to get around that.
Well, I hear Mr. Hunter, he's making a full-throated argument that what happened in 2018 has no bearing going back. And if that's the argument he wants to make to the jury, then why should I preclude him from making that argument and presenting evidence to that effect?
I don't say that he can't make some sort of argument. I'm saying that the particular phrase that there was the government passed, approved, and I forget the exact quote, it's in our memo. Johns Hopkins, during this period, be stricken. And then, however he wants to argue the rest of the testimony from there, fine. But the key point is, for those jurors, that the federal government had passed on the conduct and the management of Johns Hopkins. And that is at the core of our case, particularly punitive damages. So if we cannot get that out of the jury's mind, because let's face it, it was procured through lack of production to us and some highly questionable representations. If at the time we had that stuff, we could have attacked it and we could have done something about it. We did not have that option. The testimony needs to be stricken for us to have a level playing field. I don't know any other way around
Well,
it as trial counsel.
if I strike the testimony, then why would I allow you to present any information to the jury?
Well, that's an interesting question, whether we even need to go that far. If we strike his testimony, the jury is to disregard it.
Well, you want to know what's even more interesting in my mind is how does this impact your punitive damage claim if the risk management department wasn't reporting up? But, I mean, that's another question, but
I don't
regardless.
do that one.
I don't know.
That's
I've had nothing else going on this weekend to think, so.
This is just awful to have this at the last minute. We spent the weekend, instead of me spending 100% of my time on the closing, dealing with this issue because we were so worried about the impact it would make over on our
I hear what
kids.
you've said. I've let you speak when it really was Mr. Whitney. So, Mr. Whitney, was there anything else you wanted to say before I let Mr. Hunter have an opportunity to comment on my game plan?
I don't believe so. Judge, you made the point I was going to make. If you're going to permit rebuttal, then an instruction would make that pointless. Obviously, we've made the record. You know how we feel, but Your Honor's game plan, I would suggest that if you issue an instruction, there's nothing for them to rebut. I think that the two things there are mutually exclusive.
But how can I strike his testimony, the witness's testimony at this point, when you've just made a full-throated argument as to why it doesn't matter and why the information you presented to the jury was legally correct? I mean, I feel like I'm in between a rock and a hard place here.
I can identify with that feeling, Judge. But my point simply is, I think going further, my point was and is going further with this is ultimately going to do more harm than good, and it's going to create more confusion and prejudice than otherwise would be the case potentially to both sides. Now, if he puts on a rebuttal, you've heard what I've said. I don't have any choice but to approach it that way. But I would just suggest to the court and to all concerned that if Your Honor feels between Scylla and Charybdis on this, that the simplest and most direct approach may be an instruction. And I'll just leave it at that.
Plans to move the court for 5 minutes to discuss the matter with appellate counsel. This is a big deal, and the court presents a very cogent argument about which one and how.
Well, I'll give you the 5 minutes, and then I've got a jury on ice right this second, and I've
Yes,
got to
sir.
do something with the jury. But unless I hear something fundamentally different when you come back after having discussions with your various appellate counsels, it seems like the options that exist at this moment are, one, me striking the testimony of witness Mr. Anderson with some type of instruction to the jury that they're to disregard it, and then no rebuttal on this issue. Or two, you get some ability to present rebuttal today, hopefully maybe right after lunch, and then we will do closing arguments tomorrow morning. I'll try to instruct the jury this afternoon so that we can do closings in the morning, and then they can start deliberating at lunchtime, so, or maybe a little bit after lunch. So that seems to me to be the two paths that I can walk at this moment without. I think those are probably the two best options I've got in the situation we find ourselves in. So
The court speaks wisely on that.
take 5 minutes, and I'll be back. Let the jury know it's still going to be a few more minutes before I can get to them. Thank you.
All rise, close and recess.
Okay, please be seated, everybody. Starting with the plaintiffs, what are our thoughts at this point?
Our thoughts, Your Honor, are if it's an either or, we would, between an instruction to the jury striking the Strangers' testimony or putting in some limited evidence and rebuttal testimony of Joseph Corcoran, we would take the latter. We would like to proceed in rebuttal. We would prefer, even then, a brief instruction, but if it's either or, that's our preference.
And what's your view of doing it, let's say, like at 1 o'clock today? Give your folks time to get prepared. Your expert, if they need to look at the other documents, and then doing closing arguments tomorrow. Because remember, I still have to deal with jury instruction issues.
I understand. We prefer, Dr. Corcoran was here on hot standby this morning for a reason. He has a doctor's appointment this afternoon. We would prefer to proceed immediately into that. He has seen the documents we were provided. He was at the deposition. So he's, while not fully prepared, he's adequately prepared, and we'd like to do it sooner rather than later.
We'll have some exhibits to add, I think.
And I've narrowed down the exhibits that we would put in ahead of this.
Let's say the defense.
Judge, we would, if that's our choice and the Hobson's choice at that, we would suggest that it is simpler and more straightforward to do an instruction with reference to Dr. Anderson's testimony regarding JACO and CMS. We have one drafted that we can, hurriedly drafted, that we can show you. The other question that I would have, I don't know, we haven't discussed parameters of the rebuttal testimony proposed, and I would like to hear that, and I'd also like to hear whether or not we would be accorded serve rebuttal on a very brief basis regarding this.
Why would I give Sir rebuttal when it was the defense that opened this door?
I don't know what the rebuttal is going to be, Judge.
Well, ultimately, like I said, I've reserved on the question of sanctions. I think the question of striking pleadings is probably not something that I ultimately would physically do, given the nature of this case. But I do want to give the plaintiffs an opportunity to cure or present evidence in rebuttal to the evidence that the defense presented. So, I'm willing to do that this morning. I do think Mr. Hunter has a point. We need to talk a little bit about the parameters. So what if we do the following? Over the next 30 minutes, we can discuss the parameters. We tell the jury to come back or to stand down and be ready to go at 10:15 this morning. We'll do the rebuttal case. I'll send them to lunch. We can work on jury instructions, issues, hopefully instruct the jury this afternoon on court instructions, and then closing arguments tomorrow morning. Does that...
Acceptable. The timing is acceptable, plaintiffs. As far as sanctions, we would ask the court to reserve on DVs.
Yeah.
Excuse me, reserve, I'm sorry.
On directed verdicts. Reserve on directed verdicts. Okay. Mr. Hunter, anything further on that game plan?
No, sir.
What I'm going to do is I'm going to bring the jury in I'm gonna tell them we're gonna take a recess until 10:15, so maybe they can go outside and stretch their legs or whatever, so they're not sitting cramped in their room. So let's bring them in.
All rise. Jurors entering.
Okay, please be seated, everybody. Hey, members of the jury, I want to confirm while you're away over the weekend, you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that all correct?
Correct.
And that no one approached you about this case, is that correct?
Correct.
Now, have any of you seen any media accounts about this case?
No.
Including any media accounts over the weekend or since you last were with us? Okay. Don't pull out everything right this second. I'm going to need a few more minutes to get us to the position where we can have the rest of our case presented to you. So it's going to take me, probably another 45 minutes or so. I didn't want you to have to sit there in that room for another 45 minutes. So I'm going to let you kind of go out, maybe go outside and walk around, whatever you all want to do. I am going to ask that you be back at 10:15, and so we can proceed. It's all on me. I'm the one that is slow and not getting us to where you want to be this morning, but it's all on me. So don't blame any of the lawyers. It's all on me. So do not discuss this case amongst yourselves. Do not do any investigation and receive no information. And I'll see you back in about 45 minutes.
All rise. Jurors exiting.
Okay, the jury's out of our presence. Everyone, please be seated. Now let's talk about parameters. Mr. Whitney, do you have an outline, a plan, a thought process on this issue?
Your Honor, we have 7 exhibits that we would intend to use.
Okay, and what numbers are they? So we're
2811, 2815, 2817, 2818, 2819, 2821, and 2822. And so the rebuttal would consist of me asking some contextual questions of Dr. Corcoran and then proceeding to further contextualize that by showing him these series of exhibits. When we talk about parameters, I heard the court earlier that this is not going to be a deep dive into the Heart Institute, and I'm willing to abide by that. I think the challenge that the court faces is I would expect that the cross-examination of Dr. Corcoran would center around this was all the Heart Institute, wasn't it? So I don't know how we deal with that issue.
Well, I mean, I think, well,
Judge, looking quickly at the exhibits they've listed, the Agency for Healthcare Administration complaint investigation, 2811. I'm at a loss to understand the relevancy of that to what Mr. Anderson said or how it relates to this. I should say witness Anderson. The emails from 2817 was actually a forwarding of an email to me. It was an email that was sent to Ms. Green in real time that she then forwarded to me, and that was what was produced to the plaintiff. In other words, her email forwarded to me. So I'd like for counsel to come off of that.
Just forwarded to you.
If-
Just forwarded to
I
you.
mean, redacting out your name or reference to you,
Right.
I mean, I think that's what we've been doing with others that went to you.
Right, and then otherwise, that's an after-the-fact matter that we would respectfully object to.
I'm going to need to see these documents if you're objecting to them, so tell me which ones you're objecting to so I can make a ruling on them.
We object to 2811.
Let's pull that up, please.
Your Honor, 2811 is what I referenced in my response to Mr. Hunter's argument. This is an ACA deficiency report dated February 23rd, 2017, approximately 1 month after Maya was discharged. The two specific citations, well, first of all, it's specifically a risk management survey. If you look at the third paragraph in the left column. And the two specific deficiencies are patient rights and care, coordination of care. And the other is on page 8 of 14 at 2811-008. It's patient rights and care, patient and family education, both relevant issues.
Well, is there anything in this document that references out the Heart Institute or did you say 13 or 18 deaths that occurred in the Heart Institute?
Nothing in this document deals with the Heart Institute.
Okay, so can you go to just the next page just quickly and then...
It's been redacted for patient identification information.
Next page, please. Next page.
Judge, while you're looking at that, I'd like to call attention to the fact that it concerns itself with discharge arrangements and discharge planning.
Next page. Next page. Next. Next. Now, what on page 8 did you want to
I
highlight?
was just pointing the court to, if you see the far left column, at the bottom of the page is H023, and then it cites the specific Florida Administrative Code section for patient rights and care, patient family education. So there's two kind of overarching administrative code deficiencies in this document.
And this is a February 2017 document.
Yes, Your Honor.
Okay, next page. Next page. Next page. Next. 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 Okay. besides relevance, Mr. Hunter, any other objections?
No, sir.
Court's going to overrule the relevance objection and receive into evidence 2811. What's the next document? That Mr. Hunter, that you have an objection to.
Uh, 2817, Your Honor.
Okay, so there's no objection to 2815, is that correct?
No, sir, that's the immediate jeopardy notice.
Okay, so the court will receive into evidence 2815. Is there anything that needs to be redacted on 2815? Or has it already been appropriately redacted?
2815, Your Honor, is the CMS letter that was sent to the hospital on January 31st, 2019. Mr. Anderson, Mr. Anderson, gave you a copy last Wednesday. It's a matter of public record. I don't think anything needs to be redacted.
I don't know of anything that needs redaction on that, Judge. It is public record, and that is the IJ notice.
So we're at 2817. This is the forwarding to Mr. Hunter. So can we pull that up?
So we would redact the top block, everything above halfway down the page where it begins with Angela Green to Susan Franklin.
So we can cover up the Howard Hunter all the way through external email, exercise caution.
Yes, Your Honor. That was just forwarded to him on Friday evening during the deposition.
Is there anything besides removing your reference in your name, Mr. Hunter? Is there anything else?
The only it's just relevance, Judge. I mean, these are talking points for a board presentation, and I don't see the relevance of them.
Can I see the next page, please?
So if I could orient the court.
Sure.
The email you see there, Kim, addressed to Kim, CMS 2567 is the form number for a CMS statement of deficiencies, or what we're calling the immediate jeopardy notice. This is internal emails between the patient safety risk management teams at the hospital. If we go to the next page, they're developing talking points. Kevin referenced here is Kevin Sowers. This is the interim CEO brought in, and it discusses in a high level what they need to address based on different citations that were noted in that January 31st letter. Can we go to the next page, please? Next page. Here governing body, this is an organizational level issue. And so it talks about the leadership transition, the resignations of 8 leaders. It talks about restructuring risk management. And it talks about the very bottom bullet point there is the massive education campaign, which talks to the fear of retribution present in the hospital during the time. Ms. Green testified that of these bullet points here, 5 of them were related to risk management issues. I'll stop there.
And is there anything on this document specifically referencing the Heart Institute or those 13 or was it 13 or 18 patient deaths?
There may be, in fact, maybe the previous section there, I see at the top it says something about institute. Can you go back up a page for me? Yeah, I mean, so number 1 here, halfway down the page says halted all congenital open heart surgeries, meeting with families of children. This is the 13 deaths they discovered. Some of these are more general. I suppose we could print this out and suggest some revisions to eliminate Heart Institute issues.
This to me, the rebuttal is not going to go into the question of the Heart Institute and those specific patients' death. I don't want to talk about patient deaths
Okay, understood.
in rebuttal.
Understood.
So that type of information has got to be redacted. So anything else about this document, Mr. Hunter? I know we're going to take out your name from it.
Right. The only other thing I would point out to the court is that beyond the relevance of it, this is essentially a recitation of subsequent remedial changes, and we object to it on that basis.
Mr. Whitney?
I see the court's brain working, mine as well.
Very slowly.
Me too. Can you go to back to the advanced page to risk management again, please?
Page number
5 or 6, I'm not sure. There we go.
Judge, my point is the entire document is basically talking points on a report to the board about a response to these entire matters. So it's, I mean, that's what this is.
So I suppose it's baked in here that these are measures that they are taking in response to the immediate jeopardy notice. However, they're also acknowledgments of the conditions that existed. For example, without fear of retribution is not a remedial measure. It's an acknowledgement of the culture of the hospital.
I agree with Mr. Whitney that this identifies the problems that existed and goes to rebut the evidence that the defense presented to the jury. So, anything else, Mr. Hunter? Okay, so we're going to remove the Mr. Hunter information. We're going to remove the Heart Institute information. Otherwise, the court will receive, as redacted, 2817. Do I need to make that an A?
Probably.
Okay, so let's call it 2817A, and I'll need the plaintiffs to print out and give the clerk the redacted version.
If we could have a copy just to compare, because I think I saw another Hart reference earlier in the document.
That, please do, yes.
We will work with counsel on that. The next is 2818. I don't know if there's an objection.
Can you pull it up? Obviously, we need to take out Mr. Hunter's name there at the top.
Understood.
And was this sent to Mr. Hunter?
On Friday. Wait.
No, but did any of these emails?
This one,
Change.
he was just, Mr. Hunter was the one printing out these emails on Friday evening.
Right, I get it. But within this email chain was in 2019. Was he on?
I have not seen his name. You can correct me if I'm wrong.
That's
Okay. So we're taking his name off. Anything else in this document?
Is this the only page of it?
sorry?
Next page. What are we using this document for, Mr. Whitney?
One moment. We're using this document because, Your Honor, this is attaching the draft corrective action plan, which, if you advance to page, not right. You advance to page 7. So what you have here, Your Honor, in the left column, the large left column, you have the statement of deficiencies from CMS, and in the right column, you have the negotiation between CMS and Johns Hopkins All Children's Hospital as to what will need to be done to correct the issues and acknowledgement of the issues throughout. And this is what I was referencing in my argument earlier with respect to certain pages that speak to 8 key executives leaving and risk management not being properly integrated, etc. So I would reference certain pages here.
Well, is there, again, going back to the Heart Institute / deaths, anything like that will have to come out if this document comes in?
I understand it's a long document.
How many pages is this?
121 pages. And that's the survey and corrective action. It's 128 if you include the email.
The way these things are set up, Your Honor, is you're sent this form 2567 or whatever it is, and then the suggested plan to address it, the subsequent changes to address it, are put in a column that relates or correlates to the alleged deficiencies. So that's why the length is because of the format, if you will. But we point out to the court again that this is the statement of deficiencies, and then it's a plan that is outlined in the right-hand column to address alleged deficiencies that are the subject of this witness's testimony. So this is a document that outlines proposed subsequent remedial changes.
Well, let me just ask this. Is this a document that you actually need, or is it duplicative of the talking points? I mean, isn't your expert going to talk about it, and then does this document physically need to come into evidence if there's a lot of Heart Institute related things that would have to be redacted?
I don't think it's duplicative, Your Honor. I think the jury, given the impression they were given, needs to understand what the actual situation with the federal regulators was, and this is the best document to do that. And I can simplify this process by A309 is the, if you look back, it references failures at the governing body level. So those discussions begin at page 57 of this document and continue through page 79. And we could relatively quickly review those 22 pages plus the email to redact out Heart Institute issues.
And then just redact the other pages that
And
are...
just leave out the other pages.
Judge, it is a chronicle of subsequent remedial changes. B, it is going considerably beyond the testimony that counsel is intending to rebut. This is going deep into details of multiple matters that have nothing to do with the very simple, straightforward statement that we're rebutting. And I'm looking at page, what is it? This is page 57. There's a discussion of a plethora of details of Heart Institute issues and indications, starting with ventricular shunts and hand hygiene and working its way down.
I suspect this is actually page 51 of the report, and it just happens because of the email is identified as page 57.
Oh,
so
yes, I'm sorry. Yeah, we need to move forward 6 pages. Next, there. That begins, you see in the middle column, A309. That's the governing body failure.
Can you make that a little larger, please?
Keep going, please.
Not a little larger, thank you.
Well, again, this goes into, the top of it goes into the heart and diaphragmatic hernia program. Yeah, I think Your Honor may have hit the nail on the head as far as this thing being duplicative and unnecessarily detailed if you've got the other exhibits in.
This is what we're going to do with this document. The 20 or so pages that are, is it code A309 having to do, is that the one with the risk management component?
Yes, Your Honor.
Fine, okay. So you're going to just either redact out everything else or not include the pages. I don't care, but you know, it might seem better to leave the pages in and just redact it because the jury has been very curious about documents, but I don't care. And then for those 20 or so pages, we need to redact out references to the Heart Institute or those specific patient deaths.
By 10:15.
The art of the possible at this time. Miss Lawrence is working in overtime right now.
Understood.
what's the next, but once we do that, I will overrule the relevance objection and subsequent remedial measure objection and admit it.
And that, I'm sorry, Your Honor, just for clarification, court is letting in, starting on exhibit number 63, page 63.
Whatever the first page is with respect to when it starts talking about the risk management department issues. What's next? And that probably needs to be an A.
Understood. 2819 is next. This is internal. We will redact the top block with Howard Hunter receiving it on Friday evening. And then what follows is the management presentation. Next, please. There, we would just need this slide here. It talks about governance and culture. And then the fifth page, 1005, talks about failure to document adverse events, including disclosing our errors. That's what we would ask for from that document.
And then you're planning on redacting the balance.
We could redact the balance.
Same objections, Judge.
Same ruling as redacted. I will allow that 2819 into evidence.
2821, please.
Is this going to be just the letter or the letter and the attachments?
Right. The attachment, again, is the statement of deficiencies, so we can forego that. However, the letter, addresses, beginning on page 3, risk management issues. There would need to be some redactions here, because the first one is the deaths from the Heart Institute.
Well, Mr. Hunter.
Same objections, Judge.
Okay, so obviously that B1A needs to be redacted out. And then the previous couple of pages that talked about the Heart Institute needs to come out.
Yes.
Is there anything past this
And then
in the letter, not the attachment, but in the letter itself?
yes, Your Honor. If you go to section D, we get to governance leadership, and it discusses the ethics committee, which has been subject of some testimony here.
Anything else, Mr. Hunter?
Same objections, Judge. This is a chronicle of remedial change.
I overrule the subsequent remedial measure issue. This goes to the actual problems and goes to rebut the evidence that the defense adduced in its case in chief. So as redacted, the court will receive 2821.
There's one more page I want to show Your Honor on that, which is page 6. And there, number 4 picks up a governing body. And again, these are related to governing body issues. And then closing with 7, which would be the signature page.
Right, but number 3, let me see what number 3 was. Infection control, that's out, right?
All that above that would
Yeah.
be, above 4 would be out.
Yeah, we would add the objection, Judge, it's cumulative with the others.
Overruled that. Anything else on this document, Mr. Whitney?
No, Your Honor.
Okay, as redacted, the court will receive it.
Right, and that takes us to 2822. And It's an internal email involving the interim CEO. We would redact the top portion here with Mr. Hunter's name. And what's really critical is beginning at page 4. And we only need the top box on page 4, which again goes to governing body issues and talks about, at the bottom of that box, speaking up for safety and long-term just culture.
And then you're going to redact out that second bullet, managing heart surgery programs,
Yes, Your Honor.
and then everything else is being redacted.
And we'll redact the balance beginning at 1B in those bottom 2 boxes.
Anything in addition, Mr. Hunter?
No, Your Honor, same objections.
Okay, as redacted, the court will receive 2822.
The only thing we need to do exhibit-wise, Your Honor, is admit the mortality tables, which are the first exhibit listed. We've provided the opposing counsel. And so, for the record, those are 2060-002, and then continuing at 47 to 50.
Any objection from?
No.
Court receives 2060 pages 2, and then pages 47 through 50. Did I read that properly?
Yes, Your Honor.
Anything else as far as exhibits?
One second, Your Honor.
Because we have a couple of exhibit issues, but not related to their rebuttal.
And is it something that we can all agree to just do after we send the jury home today? Is it possible, or do we have
Yeah,
to do
there's just, the only, well, we need to, after the jury goes home, you saying, Judge?
Yeah.
Yeah, we just want to, we're asking to admit an exhibit we forgot. It has nothing to do with these issues.
So long as we can do it after I send the jury home?
Yes, I don't see why we could not.
We are done.
Okay. Let's shift gears for a moment. We have the question of juror disqualification. Do you want, because we've got time issues with the expert, do we want to postpone that discussion until, a little bit later on today?
That's fine for the defense, Judge.
Yes, from the plaintiff's perspective.
Okay, and then before we take our lunch, we need to have a final discussion and nail down the jury instructions. So what I would propose is we do this testimony, and then I guess you're going to rest after you present your evidence.
Yes,
I'll
sir.
send the jury to lunch, and then we'll work on jury instructions, deal with the DQ issue, and then take our lunch, and then come back, and the court will read the instructions so that first thing tomorrow morning you can do closing arguments. Does that game plan work for everybody?
Yes, Your Honor.
It does, Judge. I just don't know when they're going to be able to get us the redacted documents.
Well, my hope, should I just give you 10 or 15 minutes right now to work on that, and then come back, let's say, at 10:20, and hopefully we're large way there?
We'll be most of the way through it, and if there's one that we can't get redacted in that time, we won't present it at this time. We'll just move it into evidence once that gets worked out.
So should I come back at 10:20 or 10:30?
10:30 would be appreciated.
Does that give your... Okay. He's got enough time. So I will be back at 10:30. Let the jury know that we'll be starting just about 10:30.
All rise. It's closing recess.
Please be seated, everyone. Where's Mr. Whitney and Miss Lawrence? There's Mr. Whitney. How are we coming on those exhibits?
Well, Judge, I'm finishing reviewing 2817, and there were multiple things that Mr. Whitney agreed had to come out that hadn't been taken out yet.
It's a bit of a mess right now still, to be honest.
Well, what's the game plan?
We'll take up something. Should we take up something else?
Well, I thought the issue was your expert couldn't be here this afternoon.
Correct. I was just thinking while they're trying to get all the exhibits together. I don't know what else we can do in that time, but
Well, I can't deal with anything else right now.
did you bring a book? I don't know how long it's going to take, Judge.
I only need 2 or 3 of them to do the rebuttal. I don't have my arms around right now what 2 or 3 are ready. We've got 4 people scrambling, working on it, printing in the hallway, giving it missed calls. We're doing our best.
Tomorrow's Tuesday.
Let me ask our expert one question. We're just trying to figure out how late he can depart to make this afternoon in case this needs to be shifted to maybe even take an early lunch. I'm just throwing options here. And bring him back, after an early lunch at 12:30 or something. He's confirming right
Dr.
now.
Cochran, what time do you need to leave?
Your Honor, I think I'd need to leave around 2 o'clock. I'm going to call the office and see if maybe I can be a little bit late. I have a procedure.
I don't really want to start later than that because
Start later then.
you're going to have questions, and then I'm sure Mr. Hunter's going to have questions.
Yes. And so if we
I don't know, somebody from the defense side.
Sure. If we started at 12:30, I would not have more than 45 minutes of questions. That gets us to 1:15. If they have an equal amount of cross-examination, that takes us to 2 o'clock. Just an option.
I mean, I'm reluctant to ask this question, but what if we call him, let's say, at 8 a.m. tomorrow morning, ask the jury to be here super early, and we do the rebuttal tomorrow morning. We then instruct the jury closing arguments, and then maybe even let them start deliberating. I mean, I don't know. They might have to start deliberating on Wednesday.
I'll just ask him the question if he's available tomorrow. I'm going to ask that question.
Judge, are you concerned if we start at 12:30 that we won't be?
I want to give this jury as much time as we possibly can to deliberate. I would love for them to start deliberating tomorrow, as opposed to Wednesday.
So,
agree, Judge.
what's the court's reluctance, I guess, to start the witness at 12:30 so we can get all the exhibits situated? Or 12 even?
My preference is to get him on and off today.
Right, right.
Strong preference.
Right.
That being said, we are so far down this road, I don't want to do, because of rushing, I don't want to do something that is problematic.
Dr. Corcoran can leave here as late as 2:30. So if we start at 1 o'clock,
Got to be in my car, sir.
and he's not available tomorrow.
Judge,
If we started at 12, will you be ready with your exhibits?
I can confidently say yes, we'll be ready by 12 o'clock.
I believe so, Your Honor.
I'm sorry?
I said, I believe so, Your Honor.
Okay. But I also have to deal with the jury instruction issue because I really want to try to instruct the jury this afternoon unless you all say that's just, we're doing too much.
I think we would prefer that as well, to have it instructed this afternoon and get through as much as we can.
We would as well, Judge.
Now let me hear from Mr. Altenburn since this.
I don't think that disagreements and things that we have left on jury instructions are that time consuming. So,
Okay. So I'm going to bring the jury back in. I will tell them to get out of here until noon.
Sorry for the trouble.
No, it's the art of the possible. Let's bring in the jury.
All rise. Jurors entering.
Okay, please be seated, members of the jury. I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that all correct? No one approached you about this case, is that correct? And you've not seen any media about this case, is that correct? Okay. Let me tell you where we're at. And this is, again, that 5-minute issue my wife so much loves. I'm going to send you away to be back, go to lunch, and be back at noon. We're going to finish the evidence this afternoon, and I am going to do everything I can to also give you the jury instructions this afternoon, which means that the closing arguments will not be today, but will be first thing tomorrow morning. When you come back, I'm going to see if you might be able to come in a little bit earlier tomorrow. But I intend on getting the jury, the case tomorrow, deliberations to begin tomorrow. So what I'm asking is, when you come back from lunch, are you going to be able to be here at such a time so I can basically start having discussions at 8:30 with the jury? Okay. So basically, seeing if you can be here 30 minutes. I don't know. Just let me know if that's going to be a problem. If it's a problem, then we'll do it at 9 o'clock. So just let me know when you come back. Other than that, we are going to keep working today, and we're going to have information to you at noon. So I'm going to send you out, let you go to lunch now, and be back ready to go at noon. Do not discuss this case amongst yourselves. Do not do any investigation, and receive no information.
All rise. Jurors exiting.
Okay, the jury's out of our presence. Everyone, please be seated. Is there anything else about the exhibits, or can we pivot at this point to Mrs. Cross?
There's just one, on that one exhibit that I went through, there's just one phrase that Mr. Whitney and I do not agree on, redaction. The rest, I believe, we're agreeing. I don't have my highlighted copy.
Can you just put it up?
Well, I need my highlighted copy. Do you have that? Oh, it's okay, I'll find it. I found it, Judge. So 2817.
Page 9, please.
And the phrase is in here on several pages, but I think whatever ruling you make will apply. At the top there, Judge, it says, the second paragraph, there are 4 major areas we're actively working to improve. My issue was the second line, having had knowledge of complaints that allege of lack of oversight and accountability. I just thought that was probably referencing the Hart Institute. It's vague, I get it in general, but that was the one issue.
I am fine, since there's not a specific reference to the
Okay.
Hart Institute, I would leave in oversight and a lack of oversight and accountability.
Okay, that was the only, I think, disagreement on that document. Okay. That's the only one we've been through, Judge, so I have no other comments on the exhibits.
Mr. Altenburn and Mr. Elliott, can I have you both come forward and let me spotlight you there, Mr. Elliott. I'm pulling up the I don't know who wants to start talking first.
The biggest concern I think that I have at this point in time is the confusion over count 14 and the motion that I filed this morning about whether or not
The negligent training.
the negligent training count.
And
Yes.
you have now seen my,
I've seen, if it were to be removed, what you did appears to me to be the way to do that, yes. But I was quite, I put that in there purposefully, but I also knew that you'd ruled against me on the motion to dismiss on of those issues, and so I wasn't 100% sure whether you left it in on purpose or whether this was just an oversight, and I didn't want to get carried away on this. But I continue to believe, as I always have, that this tort requires, like, that the person be outside the course and scope of employment, or that there be something exceptional. And all the cases that I showed you under the 766-110 statute were in that nature. The federal cases, because the federal government is not liable under a respondeat superior, always have to have something additional by the government, and frequently that's negligent training, which doesn't come into play here. And so, all that line of cases struck me as meaning that, in fact, if the person is in the course and scope and we are vicariously liable for them, that this does not play in. And, when we get then to the damages, I think we all agree that the negligent training in and of itself doesn't cause impact or damage. What it does is it integrates with an employee who does something that causes injury to Maya Kowalski, which is the false imprisonment, the battery, or the medical negligence. And for the life of me, I think at that point the damages are 100% overlapped. I was concerned that the jury might not fully understand that, so I took the unusual step of actually asking for a nominal damages instruction on this so that they could give $1 or something if they couldn't figure out what else to do. But I just continue to believe that this count from its inception has been something poorly pled and not legally recognized in Florida. So I still believe that I should be entitled to a directed verdict on this count. But if not, then I'm not quite sure what we do with the instructions. If they insist on having it in, then it gets complicated with scope of employment. Or, as I've said at the end, push to shove, I'll just have to withdraw this because everybody wants this case to go to conclusion. And I would rather have it resolved first so that it doesn't create reversible error.
okay, before I forget, let me, Madam Clerk, on the question of directed verdict on the claim of negligent infliction of emotional distress. This is the one that I dealt with on Saturday.
Correct.
The transcript and the court minutes need to reflect that based on the court's rulings with respect to the physical impact requirement and the fact that I've ruled that death by suicide cannot qualify as a physical impact for the negligent infliction of emotional distress. Based on that ruling, that means the court's going to have to grant a directed verdict on the negligent infliction of emotional distress, and I do so at this time. And the lawyers know that I've done that, and we've already oriented our jury instructions in verdict form. I just needed to do that here in open court so that the court minutes and the transcript will reflect that. Okay, going, Mr. Elegant, or actually Mr. Altman, was there anything else you wanted me to say as relates to the negligent infliction of emotional distress?
No, Your Honor, I guess I would point out that I had made these arguments in DIN 3396 was the last time I made them, which kind of ironically was entitled "A Motion to Resolve Critical Jury Instruction Issues Prior to Opening Statements."
I'm just pretty slow, Mr. Altman. Mr. Elegant, on the negligent infliction of emotional distress, anything else you need to say about the plaintiff's position before we move on to negligent training? You're on mute, Mr. Elegant.
Your Honor, I think you summarized it. We exchanged some emails over the weekend that are, I think, Mr. Alderman and I have discussed filing a set of the various instructions with the comments in it at some point so that they're there. But I think, as you accurately recited, given the rulings, we understand the DB.
Now, let's shift gears and talk about the claim of negligent training.
Yes, Your Honor. I think I heard Mr. Altman say that it integrates in with the other claims. It's not just medical malpractice, it's some of the others as well, and we don't dispute that. And it may be that there are not additional damages, there will be nominal damages. But we have briefed previously that we don't think this is limited to somebody being outside the scope. If, again, and we've had this discussion before, if the defense either agrees or the court rules that we can still talk about training in the closing, then I think we're probably don't need it as a separate count. But if we're going to face opposition on that, we think it should stay in. If the court decides later on as a matter of law in terms of reviewing it after the fact, assuming the jury even does anything with it, you can always direct it out at that point, but at least we'll have gotten a ruling on it. So those are sort of two alternatives that we would suggest.
Mr. Altenberg.
I mean, the only thing I would suggest about their proposal on can they talk about it, then the question becomes, well, I don't disagree they can talk about evidence that's relevant to something that's left. From listening to the discussions this morning, there may be some element of this that relates to a punitive damages claim. I'm not exactly sure how that ties in, but it doesn't really have anything to do with whether someone commits one of the other torts that we're vicariously liable for, because they're intentional torts that if Ms. Beatty made a contact that was offensive and not such under intentional tort law, then it doesn't really make much difference about whether she was perfectly trained or not perfectly trained. And the same is true for the false imprisonment. And the medical negligence stuff is a whole different can of worms, because that's supposed to be a professional standard of care, and we're going right now to the jury on negligent training on an ordinary standard of care for a medical facility that is itself deemed to be a healthcare provider is now under an ordinary standard of care to provide training to another healthcare provider. I don't think that's the law, and I think we're better off getting that count out of there. And again, if there are things that are relevant that are left from this testimony that can be used for the rest of it, I can't object to relevant testimony.
How does this ruling impact, if at all, what we're talking about rebuttal?
You know, Your Honor, I was not in the courtroom when this happened, so it gives me a slight disadvantage, but my impression is we were talking about this in significant part related to negligent training and trying to show that we had accreditation. What I don't honestly know myself is whether that carried over to something that relates to the punitive claim. But the punitive claim really is whether or not the people at the high level, the officers, directors, or crew managers, were so involved in something that they become liable, or whether they were in a posture where they fit into one of those other two categories. And as you point out, it's kind of a two-edged sword for them, because it has to go up to management to be ratified, or go up to management for them to make a decision on it. And their whole line of theory here is that nothing went up the chain. So I've always kind of listened to this with the same interest that you had, that I'm not sure how it ties into punitive as compared to training, but I'm not going to tell you that I'm 100% convinced that there's not, as you use the word scintilla, of evidence of this that somehow relates to punitive damages.
What
Your
about,
Honor, if I
hold on one second, Mr. Elliott. What about Mr. Elliott's, or maybe it was your initial idea of just putting a nominal?
I only did that truthfully as a last resort, because nominal damages are supposed to be for a tort for which damage is not an essential element, and damage is an essential element for the tort of negligence of any variety. So here, there's at least nothing new in the way of damages for this tort compared to the two intentional torts and the medical negligence claims that are the predicates for this. So I'm doing that only because it seemed to me to be the best way to protect the verdict from getting some, now that I know that how much money they want to be seeking, some large number for something that doesn't really have any damages.
Mr. Elliott, anything further?
Yes, Your Honor, a couple brief things. Not correcting something, not training, not correcting, is condoning. It is ratifying. So it is relevant to the punitive damages. And I heard a reference just, well, I think this is relevant here. Something about it, not being reported up. Well, wait a minute. Not reporting to the national headquarters is not the issue. They sound like they fired the CEO of this hospital for what was going on there. That's high enough up. That's punitive damage liability of the hospital. That's who we're talking about here. The fact that they're owned by somebody else or overseen at some level by somebody higher up, we don't have to get there. Firing the CEO because of how bad this was kind of makes is relevant to the punitive damage case.
I've been warming up to Mr. Altenburn's position on this. I wish I felt as confident as you seem to feel about this claim. And is there any way I can leave the claim in with shifting a question or two, so that if I felt like after the fact I need to DV it or JNOV it, I can? I mean, I want to make sure that the law is correct and the instruction's correct.
My concern, and it's kind of for both sides here, is that at the beginning of this trial, the understanding was that we weren't going to shift to somebody outside the scope and course of employment. So they didn't put on any evidence of that. And frankly, I didn't raise that anyone was outside the scope and course of their employment, because in good faith I didn't see any evidence that I could use as the defendant to try to prove my employees were outside the scope and course of employment. So a shift to that has the questions that I put in the motion this morning, where we have to individually say, well, somebody outside scope and course. I don't think we need or should do that, because I don't really think there's any evidence of that in this case. If in fact there's no evidence of damage beyond the underlying torts, I don't see how it can possibly be harmful error to omit this, because the damages are going to be the same one way or the other. There's not going to be any harm to the plaintiff done by omission of that. And Mr. Ellicott's made a good point that some of this may still be relevant for punitive. I'm not saying that that's outside the zone here.
And Your Honor, if we could, sorry.
Go ahead, Mr. Elliott.
I would say if we can have an understanding or an agreement or a ruling that training can be discussed in closing, I think we're there. And having heard a preview of the closing, it's not a feature. I mean, if there's a reference or two, I actually missed it. And Ms. Ferrier heard it. I think she heard it. So it's not going to be a feature.
I haven't heard that. I didn't have a chance to hear the feature, but I guess my inquiry would be: is it relating to punitive damages or is it relating to something else?
I couldn't tell you
Yeah.
the context.
Yeah.
I mean, it was,
Okay.
What about Mr. Elligott's, if there's some sort of understanding? I made so many calls in this case,
and
I think this is
and
pretty much my last
I mean,
call.
I'm essentially conceding to you that I think there's a level of this that could be talked about for punitive damages, and you know, whether Mr. Anderson will go farther than that line, I don't know, but there certainly is a line there that he can go to. So.
I think I need to ask Mr. Anderson, make sure I'm not giving away something, if he's comfortable with what we've talked about.
This much I know for certain. There is a plan behind everything the defense does. And because of that, I would like for it to go to the jury and for the court to then consider these matters on JNOV. If we have to ask an additional question, we're not opposed to that. But as to the cause of action, we would prefer for it to go to the jury, and the court hasn't heard the conclusion yet of one of our witnesses.
My evil plan is simply not to have one more claim on the verdict form and to have to deal with it in closing arguments, Your Honor.
I mean, Mr. Anderson, I hear you want it to go, but like I said, I'm starting to really warm to Mr. Altenberg's position that it might be legally incorrect to let it go to the jury. That the negligent training has to be outside the scope.
Isn't that an issue for the jury, Your Honor?
Well, we don't have a jury finding currently itemized on the verdict form, and based on how this has been developing over the last 9 weeks, it's not something that really we've been focused on.
I would remind Mr. Anderson that if they're outside the scope for count 14C, then they're outside the scope for false imprisonment and battery, and that impacts his punitive claim itself.
My concern is I do not want to hear from the defense after the court rules some argument that somehow our punitive damage claim is inadequate or we failed to preserve some issue. And sure as shooting, we're going to get that from them. And so that's why unless simply submitting it is reversible error, in other words, if the court afterwards determines on JNOV to take it out, I don't see the problem with submitting it and getting their view.
Except it allows for a chunk of argument on things that probably should never have come in. I mean, the problem with if there is, as he says, a strategy, but I've been worried about trying to sort out the negligent things that the jury has heard about compared to the things that were extreme and outrageous conduct with intent. And
I guess, and this is going to sound pretty callous, I don't really care what your all's arguments are.
Good.
It's a question of what I legally have to do.
Right.
And that's, I just wish I was over the finish line on this issue where you seem to be, Mr. Altenberg. I'm just not quite there yet. I'm pretty close. I've warmed to the idea that you might be correct on it, but I'm just not over the finish line on it. And so that's my hesitation.
But your hesitation is on it as a legal issue as compared to the evidence that's going to the jury. So, I mean, it's not like the directed verdict is dependent upon whether there's evidence on this or not. It's whether whether this claim can be made by someone when there's absolutely no dispute that it's going to be 100% covered by the employer because the employer is vicariously liable. And that's, the cases that they've cited to us just don't fit that. And the little case law under 766110 doesn't seem to fit that.
Well, and I guess my concern is, let's say there's a finding of no liability on false imprisonment, battery, medical negligence, and then there's a finding of liability on negligent training.
So how could that be? Your
That-
current
that's-
instruction says that cannot be.
And that's, if your argument and your position is legally correct, then how can that be? I think
Right.
that's the appropriate
Right.
question.
And that's how you have it currently on the verdict form that you submitted to us last night. They can't answer the questions on negligent training unless they answered yes to one of those questions at least.
Mr. Elliott, I'll give you one last chance. I am, like I said, I'm more in Mr. Altenberg's camp on this issue than I am in your camp. So,
Your Honor, you've heard Mr. Anderson's concerns, and I don't know that I have anything to add. I mean, again, I think part of the problem could be addressed as long as, he's not going to be interrupted when he starts talking about training because it is relevant.
If it is wrapped at some point into the med-mal, which is what I thought we were going to do about 2 months ago with this. But as long as it's wrapped in so that my concern is not fulfilled, then I understand the need to streamline. And, of course, the law.
I'm not quite sure how it's wrapped in at this point to the med-mal. We've got those instructions are kind of what they are.
is there any question, Mr. Altenberg, that we could ask that lets me basically punt on this issue?
Judge, it's a question of law. It's not a question we can ask the jury. I'm sorry. I wish it were.
Mr. Elliott, any other question that I can punt on this issue?
No, I think if the concern, one of the concerns I heard earlier was, well, you'd have to have med-mal to answer this question on the medical malpractice part. I think you could add a line that says that. You could say, well, let's put it this way. Yes, I think you could answer a question. You could add a question that says, if you find that the training was inadequate for a healthcare provider, you would need to answer do the analysis you did above for the medical malpractice claim.
I mean, they're already going to be able to argue that whoever breaches the standard of care on diagnosis and treatment did so because they weren't adequately trained or because they fell below the standard of care. That all fits together in that package. I mean, but it's the standard question in this situation about these doctors and whether or not they deviated from the medical standard of care in treatment or diagnosis. And it doesn't create another spare question.
I think I just heard what we've been asking about, which is that we can talk about this may have happened because of a lack of training. If I was wrong, I apologize. But if I heard that, I think that may satisfy Mr. Anderson.
And can we hear the end of Dr. Corcoran's testimony before we make any finals?
Well, I guess the answer is yes, but all this has to get printed. It's going to take a while to make that happen. And so I'll be having the jury sitting, cooling their jets even more.
Talking about this afternoon with jury instructions.
Right, because, I mean, I got to print them out. And it's, I've got 11 or 12 jurors, depending on how we deal with the juror disqualification issue, plus all of y'all, the court reporter and me. And we're talking, what, close to 75, 80 pages per. Okay.
It's wild.
Mr. Elliott, I guess I've always kind of, I won't say that this has been a throwaway count, but it just kind of seems duplicative of the other counts. And I think at this point, even though I'm not fully on board with Mr. Altenburn, I'm more on his side on this one, and it just seems like it's cleaner to not have the negligent training questions in there. I think from a percentage odd standpoint of me being wrong, I've got less of a chance of being wrong on that than if I leave the questions in.
I understand, Your Honor, and I think, again, our concern, including Mr. Anderson's, and I think we heard it would be okay, as long as he can talk about training, and again, it won't be a feature of the closing, but as long as you talk about training in the closing, and it is relevant to several issues, then I think, you know.
I don't want to be foreclosed about arguments over management.
Now, Mr. Shapiro, was that shrug meaningful to this discussion, or?
I mean, not particularly, Your Honor, honestly. It's, just to be honest, it's not a feature of my closing either.
Okay, well, this is where I'm at. I think I'm going to remove the negligent training questions. I've heard some discussions, and I do agree that the question of training does go to the other tort counts that are existing. So I think we're really talking a lot about something that's not going to become an issue or should be an issue. Certainly, it also goes to the punitive damages. So I think I've got a greater chance of being correct by not asking the negligent training questions and removing that from the verdict form. So I'm going to say let's go with the version of the instructions and verdict form that I circulated this morning. And now, knowing that that's the version I'm going with, have you all had any chance to see if I've messed up the cross-references any?
Well, I'll confess that I've read this document so many times in the last 3 months that it's hard to proofread, but I didn't see anything that was a mess up on it. But the only other thing that I'm still a little concerned about, especially after I saw the calculations, which seem to be mathematically correct, is that they're lump sum for all non-economic damages, which when we get to non-duplication with the concept the pain and suffering must be for this tort, this tort, this tort, it's going to make it even harder for the jury. And so I know that you think your non-duplication instruction is adequate, but I think it's going to be tested by the closing argument, and I wish it were a little stronger. I proposed something, but you didn't get it. So.
There's so much that's been tested in this case, Mr. Altenburn. What's just one more issue?
It's a veritable fertile field, isn't it?
Okay. What I would ask is and I don't know if it's Ms. Ferrier and somebody else in your office, Mr. Altenburn, to go back and fly spec
this,
especially the cross references. I'm going to start having printing of the verdict form and the jury instructions, and if we have to throw those away and change them, I've wasted some paper. But from a timing perspective, if I can not have the jury continue to wait on me, then.
And on that verdict form, I guess all of the negligent training's out. So the one question we were uncertain about is gone. Okay, yes.
And I mean, I'm not saying that you and Mr. Elliott shouldn't look at it, but
No, fresh eyes would be a good
fresh
idea.
eyes. And honestly, I think I'm probably in the
Same mode.
same boat that you are. That I mean, if I had 4 days to put this aside and come back to it,
Right.
I would do that. But since we don't even have 4 hours, I'm not sure I'm in that position.
Okay.
So. Okay. Anything else that we can do before noon, or I should let y'all take your time, finish out these exhibits, and be ready to go at noon?
Your Honor, what time did you want to talk about the juror issue?
Can we just do that after we send the jury home today? Is that
Yes.
problematic for anybody?
No.
So defense, you're okay with just waiting until?
That's fine, Judge.
Okay, let's do that after. Let's take that one off the table until we get this rebuttal case, nailed down.
Can we come back at 10 till, just in case Ms. Crawls has any further requests for minor redactions?
That's fine. 10 till. Now, one other thing, and it probably doesn't matter since you have a lot of technology, but I was going to give the lawyers a copy. Sometimes the lawyers want them stapled, not stapled. Sometimes they want it two-sided. Sometimes they want one-sided. Is there any specific request on how you want your paper copy of the jury instructions and verdict form?
We like the stapler. One-sided or two-sided is up to the court.
I don't care about the stapler. It's just the TV, doing it right in front of the microphone.
I know. We'd appreciate it stapled.
Stapled, and if we could, just one side.
One side.
It's a thick document, one-sided, but it can be done.
Staple 2 for me.
Do you want yours both side?
I'm a big pine tree saver, Judge.
Okay. So does that go for your entire team or just you?
I think Ms. Crowell is partial to one side.
And Madam Court Reporter, I'm going to get you a copy. Do you want yours one-sided or two-sided? One? No. Okay. And Mr. Elegant, your team there in Tampa?
Your Honor, we'll just pick it up from when they come out off the, we'll print one here. Thank you.
Okay. With that, let's be back here at 11:50, and then we're going to rock and roll.